This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why ignoring a court order is done at the peril of the client and the lawyer, and why a frivolous litigation and frivolous appeal causes a default judgment to be entered against the parties. Proof of fraudulent claim received by Transamerica Life Insurance Company required it to litigate with its insureds. Transamerica Life Insurance Company sued Akop Arutyunyan and his daughter Anahit Arutyunyan for allegedly engaging in a conspiracy to defraud Transamerica into paying benefits under a long-term care insurance policy. In Transamerica Life versus the Arutyunyans, the United States Court of Appeal for the Ninth Circuit on February 22, 2024, sued to avoid paying benefits to a fraudulent disability claim. In March of 2016, Transamerica issued a life insurance policy to Anahit, which covered her father, Akop, as the insured. The policy included a comprehensive long-term care insurance rider under which Transamerica generally agreed to pay a monthly long-term care benefit when the insured has incurred expenses for qualified long-term care services. One of the requirements for triggering this long-term care coverage was that the insured qualified as a chronically ill individual. In December of 2018, Akop filed a claim for benefits under the rider, alleging that he had torn his left rotator cuff and suffered from spinal arthritis. The following month, a nurse conducted an on-site assessment of Akop at his home in order to determine whether Akop was eligible to receive benefits under the rider. Anahit also provided written confirmation to Transamerica that he had hired Mr. Prudskian as his caregiver. In light of the information provided by the defendants, Transamerica approved the claim and began paying Akop benefits. Over the next several months, because of suspicions, Transamerica conducted surveillance of Akop in order to determine whether the representations made in support of the claim for benefits were accurate. The surveillance revealed that Prudskian never visited Akop's home, in spite of the fact that on each date of surveillance, Akop represented to Transamerica and signed and certified proof of loss statements that he received between 3 and 8 hours of care services from Mr. Prudskian in his home. Based on the initial surveillance, Transamerica invoked its rights under the rider to require Akop to submit to an independent medical exam. The doctor who performed the evaluation, Dr. Molinar, examined Akop in April of 2019, and because the IME determination was sufficient to support Akop's continuing claimed eligibility for long-term care benefits, Transamerica continued paying benefits to him. Further surveillance allegedly confirmed that Prudskian did not provide care to Akop on the dates represented by Akop to Transamerica. Transamerica's further surveillance also purportedly showed that Akop was continuing to engage in activities that were inconsistent with his claimed level of impairment. Transamerica sued seeking an order that it did not owe Akop. The court, concluding that the defendants had repeatedly failed to obey court orders related to the discovery process, the district court ultimately entered default judgment against the Arutyunyans. Defendants have timely appealed the judgment, but the Ninth Circuit concluded that their arguments in the court were frivolous. Moreover, when called upon to defend his disregard of the district court's orders, defendants' counsel at oral argument in the court made multiple blatantly false statements about his and his clients' responses to the court's order. In May of 2020, Transamerica sued the defendants, alleging that they had obtained insurance benefits through fraud. Specifically, Transamerica asserted monetary claims based on fraud, civil theft, civil conspiracy, and restitution. The defendants filed their response to the order to show cause on September 13, 3 days late. Defendants challenged the district court's ultimate decision to enter a default judgment as a sanction for defendants' violation of court orders. The district court applied a measured and gradational approach in responding to the defendants' noncompliance with the court's order and the local rules. The Ninth Circuit found it is abundantly clear that the result is obvious and the appellant's arguments were wholly without merit. Moreover, at oral argument for the appeal, defendant's counsel repeatedly minimized, if not misrepresented, his lack of compliance with the district court's orders in this case. For example, at one point during argument, counsel asserted that, quote, "In terms of our compliance with the court's order, at no point did we ignore or flout our responsibility to respond to discovery," close quote. It may well be that when it comes to evaluating these multiple misstatements, this case may ultimately call for the application of what has been called, quote, "Hanlon's razor," close quote, which provides, quote, "never attribute to malice that which is adequately explained by stupidity," close quote. In view of the frivolous nature of the appeal and the multiple misstatements made by counsel at oral argument, the Ninth Circuit ordered the defendants and their counsel by separate order filed contemporaneously to show cause why the court should not impose sanctions against them. Defendants' counsel was likewise ordered to show cause why this court should not refer the matter to the State Bar of California. The Ninth Circuit upheld the district court's order deeming defendants' objections to certain items of discovery to be forfeited and requiring production of those items. By failing to present any sufficient argument in their opening brief as to why the district court's stated grounds for that decision were erroneous, defendants forfeited any challenge to that order on appeal, and in addition, it held that the district court did not abuse its discretion in entering a default judgment as sanctions for defendants' violation of the court's order. Finally, the Ninth Circuit held that the appeal was and is frivolous. In my opinion, Transamerica was the victim of a blatant fraud. Surveillance established that the disability claimed by the defendant did not exist, and so Transamerica, after giving him every benefit of the doubt, sued to end the payment of benefits to the defendants and for reimbursement and damages, only to be met with a recalcitrant defendants and defense lawyer who refused to obey any court order, lied to the trial court and to the Ninth Circuit, and may find criminal charges pending and a law license in jeopardy. The actions of Transamerica should be emulated by every insurer faced with a fraudulent claim, and the California Bar should take action against the lawyer if he cannot show good cause for his actions, and the U.S. Attorney should consider the criminal conduct of the defendants. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog and subscribes. If you subscribe, you will be provided with notice of every blog post, usually 5, sometimes 6 a week, and access to the more than 4,700 blog postings. You can also subscribe to these videos at rumble.com and on youtube.com, and if you do, I'd appreciate it if you click on the thumbs up button at Rumble or the like button on YouTube. And please tell your friends and colleagues about the blog and the videos, and let them also subscribe to help them in their profession. And if you're interested in more detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.